Our second case this morning is Quest versus Rekieta, and please feel free to correct my pronunciation of the last names. The case number for that case is A23-1337, if counsel for that case would approach.
I could ask for an indulgence.
Dave Schneider.
Pleasure.
How are you doing today?
That would be fine.
Would be undignified normally. Thank you.
Good morning, counsel.
Morning.
As I'm sure you both know, you'll each be given 15 minutes for your argument this morning, and appellant, you'll be given 5 minutes for rebuttal. If you could both, before beginning your argument, identify yourselves and your client for the audio record. And the bench is adjustable, so feel free to take your time adjusting the bench prior to beginning your argument. So with that, counsel for appellant, if you're ready.
Thank you. I am Mark John Randazza. I am here for the appellant, Nick Rekieta. I am with my co-counsel, Matt Kazaya. And with that, may it please the court. This case is about an internet celebrity beef ongoing for about 5 years. But this appeal is about predictability, consistency, and discouraging forum shopping. After years of back and forth nastiness by two men who proclaim themselves to be jokesters, this very unserious beef has become a libel tourism trip to the Minnesota courts. To embark on this trip, Mr. Quest, or as he's also known, Montagraph, or October Rains, or any number of aliases, picked through the party's juvenile back and forth banter and found statements that were void of necessary context might seem a bit out there. But in a defamation case, context is everything. Now, the law requires that a trial judge view the existing evidence at summary judgment through the substantive evidentiary burden. Now, today, this did not happen before, and today you have the task of deciding if Minnesota wants to depart from the nationally preferred framework to become a libel tourism destination. In a multi-state defamation case, the presumptive choice of law in most states is where the plaintiff's reputation is, because that's where the plaintiff's reputation is based, is a creature of that plaintiff's state law. The lower court incorrectly presumed that Minnesota law applied, but that was flawed from the start. It began with a flawed observation that if she applied Colorado law, the Colorado anti-SLAPP law is much more powerful than it really is. She presumed, I believe, that it would have foreclosed the claims altogether, when it really would have just changed that prism through which she has to look at the facts and the substantive effect of them on the law. Because the lower court said that the Colorado law gives immunity to Rekieta statements. It may, but it's far more complicated than that. What it really does is it requires that he show a degree of minimal merit. It's perhaps a very anemic qualified immunity, not a blanket immunity. Now, the factors that we should look at, there's really kind of a split in Minnesota, it seems. Some cases look at this Milkovich test. Others look at the restatement 150. I believe that you get to the same result no matter which one you look at, and I would suggest that this court adopt restatement 150.
Are you aware of any Minnesota case law that used the most significant relationship approach to resolve a choice of law issue in a tort case like this one?
Like this one, no, because this one is,
Or
frankly,
any tort case outside. I mean, it seems like you rely heavily on criminal cases.
I believe we briefed one, Your Honor, but I'd be lying to you if I said I had that citation at my fingertips right now. But if we look at it through Milkovich anyway, I think we get to the same place. First, we have to look at predictability. Well, applying Colorado law is going to serve the principle of predictability. The principle here is the case should be the same no matter where it is filed, and that's to avoid forum shopping. That's what your Nodak case says. So if the case would be different if you file it here or there, well, then we have this factor in our favor. The nationally approved approach, the one Quest asks you to abandon, flies in the face of Nodak's instruction and creates a perverse incentive to any resident of the 35 anti-SLAPP states to come and file here.
But doesn't the first factor rely on the expectation of which law would apply? And in this case, why would it have been expected that Colorado law would apply? I mean, you started out your remarks by pointing out concern about injury to reputation in Colorado, but you also said that both of these individuals are internet celebrities. So
Yes.
Isn't their notoriety really everywhere?
Well, if their notoriety is certainly everywhere. But if Mr. Rekieta were to go to another state to have his reputation taken care of, it would still be a matter of state law. It's essentially, if you have a building in another state, you're going to expect it's built to that state's building codes, not that it would be a different building code no matter who visits it. That's probably the closest analogy I could come up with. But your reputation management law, your corpus of that body of law, is created by your home state. Remember, Colorado has a different standard for defamation than Minnesota does. Not a very big difference, but enough of a difference that it could change the outcome.
Does it though, in a situation like this, when we're talking about what Minnesota considers to be defamation per se, but really an allegation, or at least, as you said, an insult that Mr. Quest is a pedophile. Isn't it true that under Colorado law, that would be considered a matter of public concern that would lead to, under at least the case law applying the anti-SLAPP statute, this heightened pretrial burden of proving by clear and convincing evidence, which was exactly the concern that led the Minnesota Supreme Court to strike down Minnesota's anti-SLAPP statute?
I could not have written a better question to illustrate the point. That's excellent. It's no. The Colorado anti-SLAPP law does not have a clear and convincing evidence standard in it. It is simply...
It's not in the statute, but the cases apply it even as recently as 2023. Colorado cases do.
So do your cases. All cases, in fact, since Anderson versus Liberty Lobby, when you're dealing, and that's a Supreme Court case, when you're dealing with a public figure in every state to be consistent with the First Amendment, you must show that a reasonable jury could come to the conclusion that you had superseded that clear and convincing evidence of actual malice standard. So yes, it can be somewhat confusing because there were the old Washington statute and the old Minnesota statute required the plaintiff to show clear and convincing evidence of defamation. That's different than saying a reasonable juror could overcome the Bose standard, the Anderson versus Liberty Lobby standard laid down by the Supreme Court, that a public figure plaintiff must show by clear and convincing evidence that the actual malice defense has been overcome.
Counsel, I want to follow up on that. So, and you raised the Washington statute, which, like Minnesota, anti-SLAPP statute, had been struck down. But unlike Minnesota, Washington then revised their anti-SLAPP statute and appears to incorporate at least 3 different ways that it can be knocked out. In other words, summary judgment, motion to dismiss, failure to plead sufficient facts, which are commonly used as, if not rule-based, statutory-based method, accepted methods to dismiss cases.
Yes, Your Honor.
If I understand your argument correctly, are you arguing that the Colorado statute, unlike the Minnesota one, utilizes, based on case law interpreting the statute, a summary judgment standard, which would, at least on its face, would appear to be an appropriate standard that would not take away the fact-finding from a jury.
Correct. LSS versus SAP, 2022 Court of Appeals 123 from Colorado, says very clearly, the court does not weigh evidence, nor does it resolve conflicting factual claims when looking at the anti-SLAPP law. But it's not just the anti-SLAPP law that we have to look at. We also have to look at the full underlying body of Colorado case law. I believe that you can have statements in Minnesota that, frankly, Minnesota might be too civilized to tolerate that would be tolerated in Colorado. In Bucher versus Roberts, for example, at the Colorado Supreme Court, it's 198 Colorado 1. I mean, as far back, that's from 1979. It's even much older than the anti-SLAPP law. Approves of abusive statements that are outbursts of anger. And I'm not going to repeat what they were there unless you order me to, but they would certainly be indelicate anywhere and might be defamatory in Minnesota. But in Colorado, the Colorado legislature and the Colorado courts have looked at their citizens and said, we're going to balance your reputational management rights and your First Amendment rights differently than Minnesota does. Now, that's certainly Minnesota's right to do that. But what you don't want to create here today, I don't think, is a Coloradan seeking an unfair advantage in a defamation case by coming to Minnesota to get a result he could not have achieved at home. He should at least have, theoretically, if we have cloned the two judges and put them on two different benches in two different states, that you'd have the same outcome. Colorado law is the law that should govern that decision-making process. So not just do we apply the anti-SLAPP law, but even if, let's say that you remand it with the lower court's instruction to apply the Colorado anti-SLAPP law and apply Colorado law, she could apply it. She might. I can't predict exactly what she'll do. I'm confident she would find that it eliminates this case. But she might say it doesn't fit the anti-SLAPP law. However, consistent with...
Hasn't the district court already ruled that if this is a summary judgment standard, that summary judgment is inappropriate at this stage because discovery hasn't commenced? And how does that decision interplay with the application of the Colorado statute?
Again, you guys must be spying on my outline because this nails the issue right there. That what she was doing was applying Minnesota law to that. So yes, under Minnesota law, her decision may have been correct. Frankly, I don't think it is, but let's presume that it is because her summary
Because
judgment...
Minnesota's procedural rules would apply. You don't disagree that the Minnesota procedural rules would apply to this proceeding?
Oh, they definitely would apply. So that's why I don't think that the Colorado anti-SLAPP laws, stay on discovery, for example, would apply in Minnesota court. Only the substantive rights come into Minnesota.
And so respondent would still be entitled, even if we agree with you, respondent may still be entitled under Minnesota's procedural rules to have additional discovery prior to a hearing on this motion if it's true that the anti-SLAPP is applying a summary judgment standard, and in Minnesota we say you're entitled to discovery prior to summary judgment.
If that discovery would change something, yes. But when we're looking at simply matters of law, it's a matter of law whether someone's a public figure, and I think we've established that. It's also a matter of law if, for example, the level of rhetorical hyperbole here would be tolerated under Colorado law. Her decision was flawed in looking at summary judgment because she failed to look through the prism of Colorado substantive law. Colorado substantive law gives a wider berth to speech than Minnesota substantive law in this circumstance.
Counsel, I want to follow up with, on Judge Larson's excellent question, because what would happen if Colorado substantive law applied? In other words, even if the special motion to dismiss under anti-SLAPP law had been presented, wouldn't there be the possibility to argue, well, wait a minute, that's premature, because if that is indeed Colorado's equivalent of a summary judgment standard of review that applies, we need to have discovery first before a decision is made. In other words, would Colorado's substantive process, well, procedural and substantive process, be the same as Minnesota's?
The procedure would be different. In Colorado, there's an automatic stay on discovery, which I have not argued would apply here. Here, you would have a presumptive right to that discovery, but upon facing a summary judgment motion, let's say I'm arguing that he's a public figure here, and here it all is, there's no discovery that's going to change that. The only discovery below that they said that they needed was discovery on Mr. Quest's medical records, which I presume he has. So what, if they need that, why did they not get that before? You know, you frequently find, this is pretty much all I do. And I always find when someone's trying to end this case early, the answer is we need discovery. And then the question is, well, what do you need? And the answer is we need discovery. It's just a circular argument. But, you know, in federal court, for example, Rule 56D, you have to at least say what it is you need. And that is, I think that's the standard. I'm sorry, I'm just going to plead ignorance on Minnesota procedure here. I'm not from here, but you know, every state that I've been in, there has been a 56D equivalent where you don't just say, I need discovery in some great universe of that concept. You say what you need. Well, what is it you need to show that this isn't rhetorical hyperbole under Colorado law?
You can't go on a fishing expedition.
I don't think you can, no. I think you have to have very targeted and specific discovery when you're faced with a summary judgment motion, whether it's under the auspices of the anti-SLAPP law or simply under summary judgment. Thank you, Your Honors.
Thank you, counsel. You'll have 5 minutes for rebuttal. Counsel for respondent. Feel free to adjust the podium.
Is there a trick to raising it?
There's a,
Button doesn't seem to be doing anything. Oh, there we go. Good morning, Your Honors. May it please the Court, my name is Christopher Bowman from the Office of Madigan, Dull, and Harlan, and I'm here today on behalf of Respondent Steve Quest. The sole issue before the Court today is relatively straightforward. Did the district court err by applying Minnesota law to this dispute rather than subjecting this claim to Colorado's anti-SLAPP statute? Minnesota's choice of law framework is based on consideration of what all today call the 5 Jepson factors: predictability of the results, maintenance of interstate order, simplification of judicial task, advancement of the forum's governmental interests, and, if still undetermined, application of the better rule of law. In this case,
do you think Minnesota law is clear that that's the correct test that we apply to the application of whether this substantive law should apply in Minnesota? Do you think the Supreme Court has clearly said that that's the correct test?
I do think
I read I think it's Castillo-Alvarez case. I don't know if the Supreme Court has clearly stated anything in terms of what our precise choice of law test is, but
I don't know, as I stand here today, I'm not aware of any Supreme Court case law that directly articulates that in a tort context. This court has said that in the Lohman versus East Grand Forks case. I recognize review was granted, but subsequently vacated by that. So I think it is established that the 5 Jepson factor test is the controlling framework here.
under our court's precedent.
Correct. And in this case, not necessarily in every case, but in this case, that 4th factor, protecting Minnesota's governmental interests, Minnesota as the forum state, so overwhelmingly supports application of Minnesota law as to be, in essence, determinative, compelling affirmance of the district court's decision.
Counsel, I have a concern about that. You argue vociferously in your briefing that that is outcome determinative, but aren't we supposed to look at the 5 factors and the 4 factors in particular and have an analysis of each one versus just saying, oh, this one factor controls the whole analysis, so you don't even need to look at the other ones. This one is the nail in the coffin.
I want to make sure I'm understanding where you said the 4 in particular. Do you mean everything other than application of the better rule of law?
Correct, 1 through 4.
Yes. Again, I think it's a balancing of the at least those 1 through 4 factors. And here, factor 4 is weighed so overwhelmingly, and I would submit that the factors 1 through 3 either similarly support Minnesota law, or for the simplification of judicial task, is probably neutral, but I don't believe that any of them support application of Colorado's law. So, if you look at 1 through 3 being either neutral or leaning application of Minnesota law, and number 4 being overwhelmingly supportive of applying Minnesota law, I think you reach the same result.
So
Wouldn't you?
Oh, go ahead.
Sorry. Wouldn't you agree that generally the presumption is the choice of law is where the plaintiff resides, and generally the plaintiff files in their own backyard?
I think, Minnesota and federal law gives plaintiffs the option to choose the forum, subject to, of course, jurisdictional and forum nonconvenience grounds, which isn't what we're here on today. And then you go through the 5, or really here the 4 Jepson factors. And I think you need to look then at, there was a lot of discussion this morning about how Colorado's statute out of the LSS case incorporates the summary judgment standard, and a suggestion that affirming the district court's decision and finding that Colorado's anti-SLAPP statute is inconsistent with Minnesota's Article 1, Section 4 right to a jury trial flies directly in the face of Leyendecker.
Counsel, that's not an answer to my question, though. with
I
all due respect.
apologize, Your
Yeah.
Honor.
My question was, isn't it true that generally there's a presumption that the choice of law is where the plaintiff resides, and that generally the plaintiff files in their own backyard, which would be, in this case, Quest's backyard is Colorado?
I don't know if I would say that generally the plaintiff files in their own backyard. And as for, is there a presumption that the plaintiff's domicile controls the forum? Again, I think is inconsistent with, again, the Lohman case, where you have a North Dakota resident injured by a Minnesota resident, in that case injured in North Dakota, and this court said, it doesn't matter, we're going to apply Minnesota's immunity statute.
Well, let me put it this way. I mean, my private practice was mostly federal, and we almost always filed in the plaintiff's backyard. I mean, it's very unusual for a plaintiff to file in the defendant's backyard. You want to be in your state. You don't want to have to incur the cost of travel. There's an assumption that the jury is going to be more favorable to you, and you don't file in the defendant's backyard unless there's a really, really, really good reason. For me, just speaking for myself, the first 2 factors incorporate the whole forum shopping. You want to avoid forum shopping. This looks like forum shopping when you file in somebody else's, in the defendant's backyard, because of the choice of law, because of the anti-SLAPP law being held unconstitutional, and so there is no anti-SLAPP law in Minnesota, which would be much, much more favorable for the plaintiff here at Quest. Why, under the first 2 factors, why doesn't that favor then Colorado because of the overriding goal to avoid forum shopping?
I would respectfully disagree that this is an existence of forum shopping. Speaking to my former practice, where I practiced in railroad litigation, no, we didn't file every case in Dallas-Fort Worth when we were suing BNSF, but where the tortious conduct occurred was controlling. And here, Minnesota is not only defendant's backyard, it's also the forum where at the very least allegedly, and I think, as the court correctly found, defamation per se, in fact, happens. I think you raise an interesting question of where the harm occurred, because the harm here, unlike the Northwest Airlines case in which the defamation had been submitted in a newspaper, local newspaper, it had subsequently been republished in Texas, but the focus was on the fact that it occurred in the local paper. Here we're now in the 21st century. The defamation occurred on the internet. So how does that play into it? And does Northwest Airlines case even apply, or should we really be looking at the restatement that looks more at the significant, I always forget the name of the significant relations test? I think, again, I would submit that this court has established that you don't look at the significant relationship test. Minnesota, to my knowledge, has not adopted that standard here, and that Minnesota applies the five-factor test. To your question about does Northwest Airlines apply in the 21st century with simultaneous publication, not only nationwide, but worldwide, I think also questions then predictability of the results. If in Northwest Airlines, where a statement is made to a local newspaper before local newspapers also published online, I think that in that circumstance, predictability of results leads to a favoring of where the newspaper is published. Now, where you have simultaneous publication globally, predictability of results becomes much harder to square there, because if this statement, there's a suggestion that because this is submitted over the internet, there's then a predictability of Colorado. But to Judge Eid, your question, assuming without conceding today that both of these individuals raised to the level of internet celebrity, that reputation exists beyond Colorado. That reputation exists potentially globally, and then when you have a predictability question, it throws the whole thing into chaos a little bit.
And I tend to agree with you on that. I think it does, which I think makes Northwest Airlines a little maybe outdated. And so this court and the Supreme Court have relied on the restatement for when we're really entering into new areas of law. Isn't that what we're really doing here? Isn't this kind of uncharted territory that we're entering into? And if so, shouldn't we look to the restatement and what other courts have done as persuasive authority?
I don't think the court needs to go that far in this case. The court certainly could. But here, where again, I think the question before the court is whether or not the district court, and this court is an error-correcting court, it has a limited scope with that. And so if Minnesota were to formally adopt the restatement and say, Northwest Airlines was great for the time that it was decided, it doesn't apply in the YouTube social media era, respectfully, that would be a decision for the Supreme Court to make as a policy-making court rather than this court.
And in fact, to the extent that the Supreme Court has applied the substantial or most significant relationship approach, hasn't that, I think that they pretty clearly said in Castillo-Alvarez that they're going to apply that test when the issue has to do with both a procedural and a substantive purpose. And I think that appellant was pretty clear in their argument that they're not arguing the procedural aspects of Colorado law. They're only arguing the substantive purpose of Colorado law, which would indicate that the most significant relationship approach is not what the Supreme Court would ask us to apply.
Precisely.
I have a question. So I think that my issue with factor number one has to do with if your client had filed this claim in Colorado, I expect that your argument would have been, my client lives here in Colorado and this is where most of his friends and relationships are, and therefore his reputation is most harmed in Colorado rather than in Minnesota. And I do think that when you look at the federal cases that are starting to wade into, in the internet age, what do we do? In defamation cases, often they say, well, a person's reputation is most harmed in the place that they live. And so is there a reason why we shouldn't think about that in context of the first factor?
I think that weighs in. Again, I would submit that there is some question about whether or not Mr. Quest is in fact a Colorado resident and resides in Colorado. But for for the purposes of this appeal
In the
today.
complaint, is it alleged that he's a Colorado
Yes,
resident?
and so for the purposes of this appeal today, I'm not arguing that it's not, we would recognize that Colorado meets that second step of Minnesota's choice of law framework where there are sufficient contacts of both Colorado and Minnesota for global constitutional perspectives, either forms, or either law to apply. Also, this court has recognized, and I think this analysis does survive an internet age evolution of society out of Northwest Airlines, where that first factor has less relevance in situations where they're not consensual transactions, where everybody knows in advance what law is going to apply. When we do business litigation, we put a choice of law in most agreements. So our client, the other client knows, hey, if there's going to be a dispute, everybody's agreed Minnesota or Iowa or Michigan law will apply here.
And counsel, I actually agree with you on that point, speaking only for myself. I think that is a correct analysis. But then the first factor, I think, goes to the underlying issue of avoiding forum shopping then, right?
Well, which I think the district court analyzed as the second issue, or the second factor, maintenance of interstate and international order. I think the district court did in fact find that they thought this was forum shopping and that factor did weigh in favor of Colorado law. Do you disagree with the district court's finding on that?
I disagree that maintenance of interstate order supports Colorado law. I see that my time has almost expired. Do you mind if I fully respond to the question?
And sorry, Judge Reyes, if I restated your question.
I want to make sure I'm answering all the court's questions. So I'm going to respond to Judge Larson, your question
Yeah.
first, and then I'll look to Judge Reyes and make sure that I've answered any questions that he has. We would dispute that the maintenance of interstate order factor supports application of Colorado law. The Colorado Court of Appeals, different divisions, can't seem to agree on what this statute means and what standard apply. This statute meaning Colorado's anti-SLAPP.
So you're saying there are other cases that have held it's not a summary judgment standard?
Yes.
Okay.
Specifically, Salazar talks, give me a moment. I have 522 Pacific 3rd at 248. That's a pin site for it. But talks about how, the division held, the court neither accepts the allegations as true nor determines truth, but must assess whether the allegations and defenses are such that's reasonably likely that a jury would find for the plaintiff. And then you get into almost the constitutional avoidance analysis that the Minnesota Supreme Court rejected in Leondecker 1, that the language of the statute is not consistent with a summary judgment standard. Judge
Yeah,
Reyes,
I would like to, if you'd respond to Judge Reyes's question.
and I apologize, Judge Reyes, would you mind re-asking the question?
Sure, if I can remember it.
I think
I know what
yeah.
it was. It was on the first factor. So I basically, I said, speaking for myself, I tend to agree with you in terms of, the business relationships and with respect to the first factor, but I think there's still, case law talks, the NODAC case talks about, you still want to avoid the forum shopping. That's still part of the consideration even under the first factor, correct?
I think avoidance of forum shopping, yes, is a consideration in the first factor. I would agree with that.
Okay, thank you.
Thank
Can
you.
I ask a question? I think you were trying to, at some point, get to the fourth factor. And just to sum up, since your time is done, perhaps you can give us your best argument as to why you believe that factor so heavily favors application of Minnesota law.
Sure, Your Honor, and I will do my best to be brief as the blinking red light grows ever near, or as in fact here. In the Leondecker decisions, this court at first tried to frame Leondecker as a Rule 12 analysis, or frame Minnesota's anti-SLAPP statute as a Rule 12 analysis. Despite the language of the Minnesota statute not being a Rule 12 analysis, the Minnesota Supreme Court said, no, you can't do that. It's not a Rule 12. This court, in fact, recognized, hey, if this isn't Rule 12, it violates Minnesota's constitutional right in a footnote in I believe it was Judge Connolly's decision in the first Leondecker appeal, or the first Leondecker appeal concerning the anti-SLAPP statute. And the Minnesota Supreme Court in Leondecker 2, I believe 2017 decision, talks about how Minnesota has a constitutional interest in affording a jury trial right and submitting a claim to requiring the court to make a determination, which even LSS says that the court has to make under the anti-SLAPP statute, would violate that right. So unless the court has any other questions, thank you, Your Honors.
Thank you. Counsel for Appellant, you have 5 minutes, and there's a little shuffling behind you, so
Okay, thank you.
I'll give you a sec. You can feel free to adjust the podium if you don't want it that high.
I can roll with it.
Okay.
So I want to address the what choice of law furthers Minnesota's interests first. Now, Colorado has forged a legal regime that protects its citizens from defamation while refusing to let that value impede on First Amendment rights. Essentially, Colorado has said, you have this much latitude when you're talking about a Colorado reputation. And I don't see how it furthers Minnesota's interests to say that if you're a Minnesota resident, we can strip you of that protection as long as they come and forum shop into Minnesota to get a different result. Should a Minnesotan have weaker rights than a Coloradan when you're debating over a Colorado reputation? I think that you'd be doing the exact opposite of serving Minnesota's interests.
Counsel, can I ask a question? Do you disagree with respondents' argument that Colorado actually hasn't settled on whether it's the summary judgment standard that applies to the Colorado statute or not? And I guess I'll just tip off that where I'm going with this is on factor 3 with regard to the simplification of the judicial task.
Yep.
Are we really going to be sending this back to the district court to have to resolve conflicts in Colorado law here in Minnesota? Because that would seem a challenging task for a Minnesota judge to do.
It would, but fortunately, you don't have that problem. His assessment of Colorado law, with all respect, is wildly incorrect, not even close. And the case he cites for that proposition is a California case. So California, looking at the California
So
anti-SLAPP law.
can you just, so the case that you're citing for the summary judgment standard, can you just explain, is that what we would consider here in Minnesota a precedential decision that's binding on all the courts, or is that, just because I don't
It
think
is.
you cited to the Northwest Reporter, so I wanted to, is that a binding case on all the courts, or is that a non-precedential decision that's more advisory? Because here in Minnesota, we would have a distinction in terms of the weight that we
Right.
would give to that kind of case. And so I guess the case that you're relying on, what is the weight of that authority?
It is the most recent appellate decision out of Colorado on it. So I guess you'd look at it like if you were in a federal court, the federal court would have to follow that. So I don't think we have
The
any.
district courts in Colorado would have to follow the decision that was,
Yes.
okay, thank you.
And as far as simplifying the task, I think I didn't give a very satisfying answer to Justice Eade when you asked me a question. And really, it was so fundamental. The predictability factor, simplifying the task. Remember, there's all this discussion of, well, why would you think that a Colorado reputation would be governed by Colorado law? Well, Calder versus Jones out of the United States Supreme Court made that very clear. Now, that's a personal jurisdiction case, but the reason that personal jurisdiction was in California in that case was because the Supreme Court said, the United States Supreme Court said very clearly, your reputation is where you are. Unless there's some overwhelming reason not to be. You know, like I could see maybe if Stephen King.
Can you remind
lives
me
in-
the year of that case? Is that a case from the internet age? Because I think respondents' argument is that this person's reputation is really on the internet. And so where his reputation was harmed was globally or across the entire United States, and that his
let's adopt-
reputation is no longer really located in Colorado, given this particular person's lifestyle and
Well, then let's adopt that. Then why not Hawaii law? Why not California law? Why not Massachusetts law? I mean, I think that we have to have some predictability, and that predictability is, I mean, when I do pre-publication review for publications, they come to me and they say, we're going to write this story, and I say, where does the subject live? That's how everybody I know who does pre-pub review does it. It says, where are we going to wind up getting sued, or what state law are we going to look at? So predictability, I think, at least in the online publication world, would be thrown into chaos in Minnesota if we decided that somebody whose reputation is everywhere but lives in a specific place, that their reputation should then be managed under Minnesota law. And remember, again, if he's sued at home, it would be a different result. So Colorado law needs to apply here unless you would like a different result for Minnesota residents, which again strikes at the core of what Minnesota's interests are. I think Minnesota's interests, if anything, should be that its people are free to speak in the same way that everybody else is, not to say that they're going to wind up getting sued in a libel tourism case by somebody who comes from one of the 35 anti-SLAPP states. And again, to remind you, I'm sorry, I'm done. If you have any questions for me while I'm still up here.
Thank you.
All right, thank you very much, and thank you, Counsel.
Thank you to both counsel for your arguments in this case. This case has been submitted, and we will issue an opinion in the time prescribed by statute. Thank you.